decided in Uganda.
Even if it's wrong.
That we want a bail. Are you with me? That is the majority. If you carry out instruction today, the majority of Ugandans want bail to stay. So that is a democracy. So what are you talking about?
The presumption of innocence until proven guilt is the basis and foundation of the right to bail guaranteed by Article 23 of the 1995 Constitution of the Republic of Uganda. However, top on the NRM legislative agenda is to scrap off this bail right, which is recognized by the international protocols and agreements and human rights agreements. Welcome to Liberteach Africa series, a program by African Justice Media. And in this episode of Liberteach, the segment of justice and property rights, we have a special guest. Yes, you will know later that he is special to this country. With me today is a man who chaired the committee that drafted the 1995 Ugandan Constitution. He served as a minister in two governments, the UNLF and the NRM government. As a Minister of Commerce, first ever senior presidential advisor, former Chief Justice of the Republic of Uganda, and a judge of the African Court on Human and People's Rights. He is Professor Dr. George Wilson Kanyeihamba. Welcome to this episode. My name is George Justice Kanyeihamba, and I'm your host. Professor, welcome to this episode.
Thank you, George. Let me emphasize that we are not related at all. But you told me how you came to be called by my name, which is very complimentary.
Sure.
That when you were born, your parents knew me, and they seem to have appreciated what I was doing for the country, and they named you after me. So I'm very privileged that you are here today for me to talk about the Constitution and human rights of Uganda. You are absolutely right that Uganda is a signatory to international conventions and protocols which guarantee the rights to bail and also ensure that any citizen or person of the world whose rights are affected has the unfettered right to appeal to a court of law for redress and the compensation if they are necessary. And that this law now is threatened by the chairman and members of the ruling party of Uganda, known as the National Resistance Movement Party, which is led by Yoweri Kaguta Museveni, and as an Attorney General, Chiwanuka, who seems to forget his role as an officer of court and the head of the Uganda Bar, with responsibility for defending the constitution of this country and ensuring that the rule of law prevails. And as I say, they have not effected the law that intended to achieve their desires, but they are threatening to do so. They have taken the first steps, first of all by the chairman of the ruling party in inviting the Attorney General, who happened to be an officer of the law, to draft a law that will substantially affect the right to apply for bail. Many people, including the Chief Justice of Uganda, are against this move,
Okay, now,
engineered by the president, and they are opposing it. Yes.
You chaired a committee that drafted the 1995 Ugandan Constitution, and knowing it very well that power corrupts and absolute power corrupts absolutely. You gave the powers to the president, most of the powers. He is the appointing officer.
You are wrong.
Did you see this coming up in the...
But then you are wrong. I never gave under the Constituent Assembly, which made the Uganda law, did not give the president powers. No. The answer
The
is that you
Electoral
are not
Commission,
correct.
the
The
judicial...
Constitution said that the powers to nominate judges shall preside in the Judicial Service Commission, which is an independent body. Therefore, the power to nominate judges is not in the president, but in the Judicial Service Commission. When they nominate you as a candidate to become a judge, you are vetted by security under the president. They vet you to see whether you are a proper person. That's the only role they do. But the president must appoint individuals nominated by the Judicial Service Commission. The act of appointing a judge is only administrative and the executive. So once they nominate Mr. X to be the Chief Justice, to be the judge of the Supreme Court, the president has no choice but to act in accordance with what the Judicial Service Commission has recommended. Because they are made of a professional people, experienced people who know who should be and should not be a judge.
Okay.
But the Ugandans have misunderstood the role and the function of the president. And time and time, journalists say the president has appointed the X to be president. That is wrong. They should say he has appointed so and so, nominated by the Judicial Service Commission. So he has no power to nominate and appoint anybody. The president acts in accordance with their device of a body, of a parliament, of a cabinet. There is nothing he does alone. But what has happened in Uganda, he has usurped the powers of advisory bodies and exercising himself illegally. So it is not a confusion of politicians. He's taking the powers up himself.
So one of the reasons the president is giving, actually, on a certain event when he was on the memorial of the former Chief Justice George W Kanyeihamba, he said that actually a person of a capital offense cannot be subjected to bail, yet he killed someone. So he prefers traditional justice system of an eye for an eye.
In no time, we are now being told that bail is a right. Right? Really? Somebody has killed a person and you see him walking here. This is a provocation, I can tell you. The one you killed is not in jail. He is dead. So for us, it is an eye for an eye.
What is your take on that?
He misunderstands the concepts of the rule of law. He also misunderstands customary law. There is no customary law which says that a suspect should be killed or should be jailed without trial. There is no such thing as African law, customary law. That is a red herring. He's trying to divert attention that the law we have is a European-made law or is English law and therefore contrary to African law. There is no African No Ugandan who wants to be jailed without trial. So to say it is an African custom that one should be arrested and not be given bail is absolutely wrong. It is an African act. Even under our traditional systems, nobody could be deprived of their liberty or life without proper trial and hearing. So we should not confuse principles with the jargon of customs. No. So it is not true. He was not a member of the delegation. And he said, Ugandans have made the best constitution they have ever made. And he will go in the bush once more if anybody should interfere with that constitution. The provisions about bail and the right to be heard were debated very extensively by an elected Constituent Assembly. After protracted war of civil war, where everybody lost, and a sad episode in our history, where I, Museveni, and your relatives were lost, fighting for the right to be treated under the law. Having helped him to become president, and having ruled this country in accordance with our laws and the Constitution for the first 10 years or so, he decided to introduce authoritarian regime. We must know the history. To the extent that we have reached a stage where he says he's not a servant of anybody. When I first abandoned my career, university career in the United Kingdom, and served him in the bush, he and I were subservient to the law, serving the interests of the people of Uganda. He has now denounced us and denounced the provisions of the Constitution. He wants to change the principles outlined at the beginning. The presumption of innocence is a fundamental principle in democratic societies like Uganda we are hoping for. But he wants us to change and say once you are suspected of being a criminal, you are guilty immediately. Even if you are innocent, you must presume guilty and you are refused bail until after 90 or 180 days.
Okay.
When the court comes. So, he wants us to establish in Uganda the presumption of guilt. That whenever somebody cries foul, someone say even if they are wrong, that you are guilty of offense, we should presume you are guilty unless you prove innocent. That is not acceptable in Uganda. That's what we are fighting against.
Okay, now you talked about the democratic principles of the country. What is up for democracy if the majority decide? Is it true that the majority can decide what is right? Because sometimes the majority could be on the wrong side, yet truth is there.
The majority decided in Uganda
Even if it's wrong.
that we want a bail. Are you with me? That is the majority. If you carry out instruction today, the majority of Ugandans want bail to stay. So that is the democracy. So what are you talking about?
Okay. Now,
Because when this matter came, it was rejected by the Chief Justice, by all the judges. You have not found one judge who says the president is right. The legal profession was against it. Learn the people on the law against it. All the law students from 12 universities in Uganda, all of them opposed the proposal to scrap bail, the right to bail. So you, George, what do you mean if the majority of the people want it to be scrapped? Where are they?
Okay, some of the reasons the NRM is giving is that there is
By the way, I don't want you to talk about NRM. NRM as a party has not adopted this program. The program was introduced by their chairman, who has convinced his Attorney General to bring a draft. They are calling a caucus. The caucus is made of MPs. So the caucus is not the NRM party.
And won't they support it when it's brought in Parliament?
Pardon?
Won't they support it when it's brought in Parliament? Just like other amendments.
Tell me, what is a caucus? Is it in our law? Do you know what it is?
It's maybe when they bring in to manage their party.
No, but what you are saying that if they bring in the party, who are they?
They have the majority
What is the majority?
in Parliament.
Excuse me. Is it parliament or is it a caucus? Could bring a law and take it to all the shepherds in Uganda. 1,000 shepherds, and they pass it. But are those shepherds members of parliament? Please, let us call a spade a spade. Parliament consists of people elected in constituencies geographical or representing certain groups, women, the youth, the workers, and soldiers. We know them. These are the parliament people who will sit and pass any law that finds. They have not sat. You see, the problem in Uganda is when somebody shouts, let us change the law. The debate will never say there is no need to change it. The shout is, how shall we change it? Let us change it. Everybody is called. For example, I am against touching bail provisions.
Don't touch it.
Even today there was an article. Those of you can read it in the New Vision. My letter is there. So my view is we should not touch it. But when Museveni said we are going to amend it, the debate shifts from don't touch it, it becomes how do we change it?
Okay.
Which is wrong.
The
I am saying now in this interview, all Ugandans join me and the students of the law schools. We do not want change in the right to bail. It was long settled. Today I cite President Museveni himself. In 2017, suspects were acquitted, but rather were released on bail in the High Court. The Black Mamba. I was a judge then. Justice James Ogola was the principal judge, head of the High Court. He was present when the Black Mamba attacked the High Court and forcefully released suspects who had been granted bail. The whole judiciary, like today, we didn't keep quiet. We went on strike, all of us. And Museveni regretted the incident. said that those people were unruly and it will never happen again. But he was very complimentary. He cited my judgment in the case of David Tinyifuza versus Attorney General, in which I gave the lead judgment and said, described the functions of the three organs of government, meaning how they are to be spent public funds, the executive is supreme. And in adjudicating and settling disputes, the judiciary is sovereign. And he said then, citing my judgment, that the right to bail was settled by Kanyeihamba in that judgment, telling the judiciary, including the Prime Minister, senior cabinet ministers, and the Chief Justice, and it will never happen again. 2021, he's saying what he promised was false. And yet you, journalists and people who are asking us questions, you don't challenge him. You say, have you changed your mind? What has happened? In 2086, when he first became the president, he made a speech at the Addis Ababa, at the summit of heads of state. And he said the trouble with applicants, they overstay in the office. But Ahmed knew in 1986 that he would overstay. He would be one of those guilty leaders of nobody. Again and again, the president has contradicted himself. He fought the election in 2021 this year. And when he was declared a winner, he told the whole world that one of his opponents, the runners-up, Senator Muchegulanyi, had massively rigged the election. If that is true, he should have joined those petitioning to have the election nullified so that we have another one. Because once you convince the world that the election was massively rigged, then obviously they cannot be a winner who won fairly. Then the chairman of the Electoral Commission, Justice Jabakama, said he had dismissed 81 electoral workers because they had messed up, been corrupt, and had messed up, whether had mismanaged the election. Those two pieces of evidence, both by Museveni and Justice Jabakama, are more than enough to allow a court of 15 justices of the Supreme Court or of the Court of Appeal to say, we have no choice but to nullify this election and hold one which will be conducted in accordance with the laws. So why should we even contemplate that the NRM will pass the law to amend the right to bail? I have pointed out on the other part that we are signatories to the United Nations Charter, to the Universal Declaration of Human Rights, and to the AOU Charter and the protocols on human rights. Then what you should be campaigning for is that before we change our own law, Uganda should get out of these organizations.
International protocols.
Hmm?
International agreements.
Yes.
Human rights.
Yeah, it should get out. Because if we change our bail rules, we shall be breaching international law. And in order to be safe, let us withdraw Uganda from international obligations before we start following the biblical saying by Jesus, first remove the beam from your eye before you complain about the speck in your brother's eye. Wow.
And that brings us to a short break. Kanyeihamba is a man known of his word. He stands for his word. He's a man of integrity and he's known as a controversial judge. Let us go for a short break and come back in just a minute.